Today we finally settle the debate about Israel-Palestine protests on college campuses. Look, I'm a lawyer. I'm not an idiot. Now, these protests have been all over the news, whether it's Columbia in New York, UCLA in Los Angeles, or in the backyard of Dean Chemerinsky's home. For example, on the night of April 30th at the campus of UCLA, pro-Palestinian supporters had occupied an encampment they built near the campus for over a week, demanding that UCLA divest from companies tied to Israel's war effort and boycott Israel-run universities. That night, a group of masked people entered the encampment and violently attacked the pro-Palestinian protesters. This attack happened hours after the outgoing UCLA chancellor declared the camp illegal. The violence continued for hours while campus security stood by waiting for backup or further direction. Eventually, the California Highway Patrol and Los Angeles riot police were able to resolve the chaos, but by this time at least 16 protesters had been significantly injured. No arrests have been made as of the filming of this video. The UCLA administration issued requests for assistance from the larger UC system on April 25th and April 26th to deal with those protests, but those requests were subsequently canceled. So today we're going to talk about the legality of the protests and counter-protests at UCLA, Columbia, and the dean of the UC Berkeley School of Law, Erwin Chemerinsky's backyard. And what about the dramatic, sometimes violent responses to the protests? Now, immediately after the April 30th incident, UCLA and the California governor's office launched investigations to find who was responsible for the slow reaction that night. UCLA Chancellor Gene Block issued a letter to the UCLA community addressing the deep pain seen on campus and offering support to students, faculty, and alumni affected by these events. In this letter, Block also called for the encampment to be disbanded, saying, quote, "In the end, the encampment on Royce Quad was both unlawful and a breach of policy." He wrote, "It led to unsafe conditions on our campus and it damaged our ability to carry out our mission. It needed to come to an end." Now, if you've never been to the UCLA campus, the Royce Quad is about as central to UCLA as it comes. It's right in front of Royce Hall and the Powell Library, and there were many reports of students being accosted and prevented from getting to class because of this particular encampment. Though it certainly appears that not all students were prevented from getting to class. Now, pro-Palestinian protesters attempted to refortify their encampment and hoped to continue protesting on the UCLA campus, but on May 2nd, after a 9-hour standoff, which resulted in more than 200 protesters being arrested, the encampment was torn down by law enforcement for good. And tensions at UCLA had continued after the violence at the encampment. On Saturday, May 4th, around 20 professors protested outside of a gala held at the campus's Hammer Museum, where its outgoing director was being honored. Then on Monday, May 6th, several dozen more students were arrested. According to KTLA, these 43 individuals were detained for conspiracy to commit burglary and subsequently released after being processed. Now, protesters at other college campuses have been met with a much different reaction by college administrations. Columbia University student protesters built a similarly erected encampment on their campus, but no great incident of violence broke out there. Though instead, New York police broke into a campus building after learning that the building had been occupied, vandalized, and blockaded by protesters after the university asked them for support. Not surprisingly, Columbia has received mixed reactions to their response and their large-scale arrests of these students. But protesters haven't kept their activities just to college campuses. On April 12th, at a private dinner held at the UC Berkeley Law School dean's home, pro-Palestinian protesters interrupted the dinner to speak about tragedies suffered by Palestinians. Now, in the wake of all of these different events, many people have made a blanket pronouncement that all of these different protesters had First Amendment rights to conduct these protests. And similarly, others have made blanket pronouncements that none of these protests had First Amendment protection. But as usual, the truth lies somewhere in the middle because all three of these different scenarios are analyzed differently. Now, you're probably aware of the First Amendment, which protects the freedom of speech, the press, assembly, and the right to petition the government for a redress of grievances. But one of the most important considerations when discussing the First Amendment is to understand that the First Amendment only restricts the government. So the First Amendment can only be violated by government actors or entities. This means that when we're talking about whether someone's First Amendment rights are violated, we're necessarily talking about whether a government official or agency has prevented those individuals from exercising their constitutional rights. The actions of private entities or other individuals are most likely irrelevant to whether your First Amendment rights are violated. Asterisks, there are always exceptions to that. But traditionally identified as the four protections of the First Amendment, speech, press, assembly, and the right to petition the government for redress, protesting may involve all four of those rights. Now, to understand the freedom of speech, you have to understand what speech is considered worthy of protection. But generally, freedom of speech is considered the largest category. And speech has been interpreted by U.S. courts to include both spoken and written speech, as well as other forms of expressive displays. Essentially, all expressions can arguably be considered speech and protected under the First Amendment, except for the narrowly excluded categories explicitly established by the courts. These exceptions include speech related to obscenity, fighting words, incitement, and threats. And similarly, speech that explicitly forms the basis for a legal claim, such as defamation, fraud, and speech integral to criminal conduct, will also not be protected. Now, once we've established that the incident incident of speech does not fall within one of the narrowly defined exceptions to the First Amendment protection, we can move on to consider what level of scrutiny the government will apply to consider the speech's deserved protections. Scrutiny essentially just means the level of justification that the government has to have in order to restrict anyone's particular speech. And as we've talked about many times on this channel, often the whole ballgame is what level of scrutiny is applied. Now, there are generally two types of scrutiny that apply to speech-based regulations: strict scrutiny and intermediate scrutiny. And it all depends on whether the regulation is content-based or whether it's a content-neutral regulation. Now, content-neutral regulations are government actions which regulate speech incidentally in order to achieve some separate purpose apart from the content of the speech. And there are three basic categories of content-neutral regulations. The first is a time, place, and manner regulation, which is meant to restrict the time, place, and manner of how speech can be expressed. A typical example of a time, place, and manner regulation is a local ordinance permitting signs to be posted a certain number of feet away from roadways within city limits. A second category of content-neutral regulations happen when the government is attempting to regulate the secondary effects of particular speech. And the final category of content-neutral regulations occurs in situations where the government is not acting to regulate expression, but speech and conduct are mixed. Content-neutral regulations are treated to what's called intermediate scrutiny, and to pass intermediate scrutiny, a regulation must 1. Be justified without reference to the content of the speech, 2. Be narrowly tailored to serve a significant government interest, and 3. Leave open ample alternate channels of communication for speech or information at issue. Now, content-based regulations, on the other hand, regulate speech for that very reason, to control the content of what speech is being expressed in a particular forum. For hopefully obvious reasons, these regulations are treated with much more care. So much more care that they are presumptively unconstitutional, meaning that when a challenge is raised, the government must prove why this law does not violate the First Amendment, as opposed to the burden being on the challenger, which is typically the case. So in order to survive First Amendment challenge, content-based regulations must pass what's known as strict scrutiny. Strict scrutiny requires that the government show that the law or other government action is the least restrictive means of advancing a compelling government interest. And a law can be content-based in two ways, either on the face of the law or plainly within its text, or because of a discriminatory purpose. One example of a content-based action on its face is a law requiring manufacturers to include certain information on packaging labels. And an example of a content-based action with a discriminatory purpose is a prohibition against burning the American flag. And generally, the final thing that we need to consider when looking at First Amendment protections is what forum the speech is in. Courts have defined 4 categories of forums for First Amendment analysis. 1. Traditional public forums, 2. Designated public forums, 3. Limited public forums, and 4. Non-public forums. And those are ranked from lowest to highest in order of the government's ability to restrict free speech there. Now, with the highest protections, traditional public forums are defined as places which, by long tradition or by government fiat, have been devoted to assembly and debate. These 4 include places like sidewalks, streets, and public parks. And U.S. courts will allow content-based regulations of activity protected under the First Amendment in a traditional public forum only if the government can show its regulation is narrowly drawn to serve a compelling state interest and that it is narrowly drawn to achieve that end. Though time, place, and manner regulations are permitted in traditional public forums, as long as these regulations are narrowly tailored to serve a significant government interest and leave open ample alternate channels of communication. Now, a designated public forum is one which is created by purposeful government action when the government intentionally allows property to be used for public expression, even if not traditionally done. The central hallmark of a designated public forum is that it's required to be generally accessible to all speakers. The government is not required to establish these forums, but when they do, they are treated with the same scrutiny as traditional public forums. Examples of designated public forums are university meeting facilities and a city auditorium. Next, a limited public forum is one in which the government has expressly limited the subject matter and/or speaker allowed within the forum. Examples of limited public forums are a public school assembly hall after hours or a city hall meeting. And then finally, a non-public forum is one which is not by tradition or designation a forum for public communication. This could be the government space in which the government is acting as the manager of its internal operations, for example, the offices of government employees or military bases. So in both limited and non-public forums, government restrictions on speech will be permitted only if they are content neutral and reasonable in light of the purpose of the forum. So this is the framework for analyzing whether speech will be protected under the First Amendment. First, determining whether the activity is speech. Second, determining whether the government action in question is content-based or content-neutral. And 3, determining the forum of the speech and the restrictions that are taking place. Now, if your First Amendment rights are being violated, you'll want a good lawyer. But if you want a great lawyer, my law firm, the Eagle team, can help. If your loved one is suffering from mesothelioma, because asbestos exposure can take decades, if you've suffered a data breach, especially if you got one of those data breach letters, or were involved in a car crash, or just about anything else, we can help represent you or help find you the right attorney. It's so important to talk to a lawyer early in the process to learn what your options are and maximize your recovery. So just click on the link in the description or call the number that's on screen for a free consultation with my team. Because you don't just need a legal team, you need the Eagle team. The link is down below. Now, there's also the wrinkle of free speech in public schools themselves. In 1969, the United States Supreme Court considered whether public school students retain their First Amendment right to free speech while they are at school in a case called Tinker versus Des Moines Independent Community School District. And the court answered this question in the affirmative, finding that the students did not leave their rights at the door. The protesting students in Tinker did so by wearing black armbands to school. The court found that behavior such as wearing armbands, t-shirts, or passing out leaflets was well covered under the protections of the First Amendment. And the court also established a standard to determine when protesting is within or outside the bounds of the First Amendment. This standard is that public school students are permitted to protest unless their protesting materially and substantially disrupts classes or other school activities. Now, private schools, on the other hand, aka schools which do not receive state or federal funding, are not governed by the First Amendment. This means that private school students do not have a First Amendment right while attending school or on school property. Though private schools typically have codes of conduct which regulate expression and student protests. And private schools must substantially comply with their published codes when they discipline students or faculty for speech or expression. So, does the First Amendment right to free speech protect the ability of UCLA protesters to stay on campus despite the forcible removal? Well, we don't have a full explanation of why the UCLA chancellor decided to declare the encampment illegal, but we can make some assumptions in our analysis. Well, first we need to consider whether the government action is content neutral or content based. UCLA framed the decision to declare the encampment illegal as a campus safety decision necessary for students, faculty, and public safety. And the government's intention behind the restriction matters. And in this case, at least the explicit intention was to increase public safety on campus. So assuming that to be true, the decision to close the encampment would probably be a content-neutral government action. And then we have to consider the forum in which the protest took place. The protest occurred in a public area of the UCLA campus, primarily on the steps of an auditorium hall. And this is a traditional public forum because the government has traditionally protected them for similar protests. And UCLA would likely be able to show that this action was justified without referencing the content of the speech. The violence that occurred posed a serious concern of continuing violence, and therefore the justification of protecting public safety would likely be sufficient in this case. Now, where UCLA might get into trouble is where they left open ample alternative channels of communication for the speech or information at issue. After the encampment was closed, protesters were arrested elsewhere on campus. UCLA has an obligation to maintain a speech for peaceful protest to speak, and it probably is not permitted to close all channels on campus. And similarly, under the right to assembly and the Tinker analysis, UCLA would probably be able to show that the encampment activities were materially and significantly disrupting class activities. Though it's not yet settled in federal court whether UCLA failed to meet a burden to protect their students during the encampment violence and whether their failure to do so affects the ability to later declare the encampment illegal. Now, in the Columbia University protest, the government action of forcibly removing the students from the campus buildings is likely also content neutral. The students were not removed because they were necessarily pro-Palestinian supporters. They were removed because they were occupying a college building. But for protests on the Columbia University campus, the analysis is a little different because Columbia is a private university. This means that Columbia students can't really claim First Amendment protections while on campus if they're being restricted by the college itself. Instead, Columbia students are only protected by the university published code of conduct. And the Columbia Code of Conduct makes this statement about freedom of speech and expression, quote, "The university recognizes only two kinds of limitations on the right of freedom of expression, and both are to be narrowly construed. First, the university reasonably regulates the time, place, and manner of certain forms of public expression. Second, the university may restrict expression that constitutes a genuine threat of harassment, that unjustifiably invades an individual's privacy, or that falsely defames a specific individual." So while the law is different, the result is probably the same. In this instance, the university's action would likely be construed as a content-neutral time, place, and manner restriction, and the students were not removed because they were pro-Palestine supporters, they were removed because they had occupied a building. And while most of these First Amendment issues we've discussed have been fairly nuanced, there's one instance where the protesters really ought to have remembered the old adage, "There's no free speech in the dean's backyard." Or at least that should be an old adage. You might have seen the videos of UC Berkeley students protesting at the home of Berkeley Law Dean Erwin Chemerinsky, and a private home, even when owned by a government official, is not a public forum of any kind. And even though the dean was holding a school-related dinner, it's likely that you're not going to have First Amendment rights within another person's private home. It shouldn't be surprising that you can't go into someone's private home, say what you want to say, and then claim your First Amendment rights are being violated if you're asked to leave. But that's not the end of the analysis, because not all protests are created equal, and not all responses are created equal either. When white nationalist Richard Spencer held a rally at Texas A&M in 2016, it triggered protests. In 2017, the university canceled Spencer's speech and decided that only campus-sanctioned groups could bring in outside speakers. In 2019, Texas lawmakers addressed this scenario by passing a law giving students more free speech rights on campus. But lawmakers were motivated by incidents like the one involving Spencer, where conservative speakers felt that they had been censored. So Senate Bill 18 prohibits universities from considering any anticipated controversy related to the event when approving guest speakers on campus. The Texas law recognizes that, quote, all persons may assemble peaceably on the campuses of institutions of higher education for expressive activities, including to listen to or observe the expressive activities of others. And the bill says the common outdoor areas of the institution's campus are deemed traditional public forums, as long as their conduct is not unlawful and does not materially and substantially disrupt the functioning of the institution. Now, this is a viewpoint-neutral law, and as written, it protects the right of students to protest outdoors in the common areas of campus as long as they don't disrupt the ability of the college to function. However, there was one viewpoint that Texas Governor Greg Abbott didn't really tolerate, and that was criticism of Israel. In 2017, Abbott signed a law prohibiting state contractors from boycotting Israel or expressing any viewpoint critical of Israel. The law was enjoined by a federal court because it violated the First Amendment. Then, in March of 2014, Governor Abbott issued Executive Order GA 44, which directed public universities to take action against speech that was anti-Semitic. And the order stated that universities must review and update free speech policies to address the sharp rise in anti-Semitic speech and acts on university campuses and establish appropriate punishments, including expulsion from the institution, ensure that policies were being enforced on campus and that groups such as the Palestine Solidarity Committee and Students for Justice in Palestine are disciplined for violating the policies, and include the definition of anti-Semitism adopted by the state of Texas in section 448.001 of the Texas Government Code in university free speech policies to guide university personnel and students on what constitutes anti-Semitic speech. And the executive order singled out particular words. Quote, multiple protests and walkouts have been staged by universities' student organizations, with students chanting anti-Semitic phrases such as from the river to the sea, Palestine will be free, which has long been used by Hamas supporters to call for the violent dismantling of the state of Israel and the destruction of the Jewish people who live there. And across Texas, public universities responded by banning the words in the executive order. Here's University of Texas San Antonio administrator warning the students not to chant from the river to the sea, Palestine will be free.
So the executive order states that language such as from the river to the sea is considered anti-Semitic speech. And so we're asking for folks to refrain from that because we are required to enforce that that is not language that's used.
And she says that students who use those words would be referred to law enforcement. Not surprisingly, two student groups have now sued Governor Abbott, UT San Antonio, and the University of Houston, alleging that the executive order singles out pro-Palestinian organizations for punishment based on their political viewpoints. And the complaint references the video at UT San Antonio. Quote, at UTSA, plaintiffs spoke with a campus official who confirmed that it was UTSA's understanding that Governor Abbott's order forbids students from chanting from the river to the sea, Palestine will be free, during their protest. During a recording of that conversation between YDSA members and a UTSA campus official, a YDSA member asks what they can and cannot say. And the campus official states explicitly that they are not allowed to use the slogan because it was written specifically in the order. Now, that political slogan almost certainly doesn't constitute fighting words and is not a call for imminent lawless action, which means that it is a content-based regulation and is unlikely to withstand First Amendment scrutiny. But student protesters should be aware that their conduct might cross other lines. Federal prosecutors can charge a person with a hate crime for bias-motivated conduct under a variety of federal hate crime statutes. For example, 18 U.S.C. Section 245 makes it unlawful to willfully injure, intimidate, or interfere with any person or attempt to do so by force or threat of force because of that person's race, color, religion, or national origin, and because the person has been doing one of the following: enrolling in or attending public school or college, or participating in or enjoying a service, privilege, program, facility, or activity provided or administered by a state or local government. So, for example, in 2016, two University of Mississippi students pleaded guilty to violating Section 245 after they placed a noose around the neck of a statue of James Meredith. Meredith was the first black student to attend the university. This prosecution hinged on the student's admission that he, quote, knew the appearance of the rope and flag would be threatening and intimidating to African-American students. But you can see that sometimes the line between expressive conduct and threats and intimidation meant to specifically prevent people from taking certain action can sometimes get very blurry. And federal hate crime laws have been used to prosecute defendants who engage in prohibited conduct against people of various religious backgrounds and ethnic groups, including members of the Jewish and Islamic faiths. Though there has been a spike in anti-Semitism on college campuses, and there's also been calls calls to prosecute protesters who target Jewish students. In this video, protesters seem to block a Jewish student from entering the UCLA campus, and in this video, the protesters are blocking Jewish students from crossing a walkway.
I have my hands up. I'm not hurting them. I'm not hurting them. That's what they do. That's what they do, everybody. You guys are promoting aggression. You guys are promoting hate. We're UCLA students, we deserve to be there.
And here's a third video from UCLA which shows protesters refusing entry to any Jewish student who says they are a Zionist.
You guys want to prevent Jewish students from entering? Fine.
Now we got a couple Jewish students. Are you Zionist?
Yeah, of course I'm Zionist.
Yeah, we don't like Zionists in a thousand.
And we don't know if the Justice Department will prosecute anyone here, but there's certainly elements of the same kind of hate crimes that were prosecuted at the University of Mississippi. But students on both sides of this issue have said that they felt threatened by their classmates' speech. Now, speech that makes people feel threatened or disturbed might still be constitutionally sound, but there is an exception to the First Amendment for speech that incites imminent violence or lawlessness. But we generally don't want the government to persecute people because of their political speech. That's why it's hard to convict someone for inciting violence based on their opinions. And we've talked a lot about imminent lawless action on this channel, mostly in relation to Donald Trump's January 6th speech at the Ellipse. But Trump is not being prosecuted for giving this speech because it's really hard to prove that the speech incited a riot. And the current standard for imminent lawless action comes from Brandenburg versus Ohio, where the Supreme Court held that the Ku Klux Klan's First Amendment rights were violated by an Ohio criminal syndicalism law. And in Brandenburg, the court said that the government can only prohibit speech if it is, quote, directed at inciting or producing imminent lawless action, and it is, quote, likely to incite or produce such action. And that's a really high bar, and chanting political slogans usually doesn't cut it. Now, hate speech alone is still constitutionally protected, which is why some people think that chants like "from the river to the sea" constitute fighting words. Now, technically, fighting words aren't protected speech, but the Supreme Court has drastically limited the scope of fighting words because it's so hard to define which words really do provoke a violent response. But the classic definition is words that, by their very utterance, inflict injury or tend to incite an immediate breach of the peace. And generally speaking, even in highly charged protests, those kind of slogans don't qualify as fighting words, and thus still probably receive First Amendment protection. Now, on the other hand, a lot of these protests, whether they are peaceful or non-peaceful, have provoked quite a response from law enforcement. And we've talked a lot on this channel about excessive force by police officers. And in this context, there's probably a lot to choose from. Here's 65-year-old history professor Steve Tamari being body slammed to the ground by police while he was filming them at a protest at Washington University in St. Louis. And it's worth remembering that even if you disagree with a professor's message, police are still not entitled to use excessive force. And there are other indications that the police responses to some of these protests have gone too far. For example, at the University of Texas, Austin, police arrested 57 protesters for criminal trespass. A judge then dismissed all 57 charges because of a lack of probable cause. Probable cause is the legal justification that's necessary to charge someone with a crime, but according to the Texas Tribune, quote, those affidavits gave few details on each individual incident other than to state in various wording that each arrestee was told to disperse but did not. And the local prosecutor explained that the officers just hit copy and paste to fill out the arrest affidavits. And interestingly, the incident at Dean Erwin Chemerinsky's house involves all of these issues. As he wrote in The Atlantic before his annual dinner with students, flyers started appearing on campus. Quote, no dinner with Zionist Chem while Gaza starves. The poster declared in large letters. Students sometimes refer to me as Chem. It also included a caricature of me holding a bloody knife and fork with what appeared to be blood around my lips, an image that evokes the horrible anti-Semitic blood libel in which Jews are accused of killing and cannibalizing Gentile children. The poster attacks me for no apparent reason other than I am Jewish. The protesters did not specify anything I personally had said or done wrong. But Dean Chemerinsky allowed the poster to remain up on campus because he thought it was protected by the First Amendment. But again, a dean inviting students to his home does not make that home a public forum for protests. The news is so turbulent that many people are avoiding it altogether, but that can't be the solution. But there are ways to stay informed without feeling captive to the chaos. Luckily, today's sponsor, Ground News, is the solution. It's hard to capture just how different the experience of reading the news is on the Ground News platform. They give you a bird's eye view of the entire media landscape. So instead of being swirled around in it, you're outside looking at all the moving parts. The best example of this is the Ground News blind spot feed. Ground News uses patented technology to survey the media landscape and group together articles about the same topic. Then they organize them according to the political bent of the publication and highlight stories that are receiving a disproportionate amount of coverage from one side. What I love about this feature is I can anticipate what certain relatives who only watch Fox News are going to say when I go visit family. And that's what this is all about, right? Dunking on boomers. Ground News is my favorite way to get the news. And as a legal eaglet, you can save 40% off of Ground News Vantage subscription by clicking on the link on screen or down below. This subscription gives you unlimited access to every feature, including the blind spot feed. And by subscribing, you'll support an independent news platform working to make the media landscape more transparent. So click on the link below. And after that, click on this link over here for more Legal Eagle, or I'll see you in court.